Good morning, and welcome to the first of a two-part series on the implementation of an updated tool to conduct all appropriate inquiries. That tool is ASTM E152713, entitled Standard Practice for Environmental Site Assessments, Phase 1 Environmental Site Assessment Process. Our goal is to give you perspectives on the new ASTM standard from both a legal and environmental consultant point of view. My name is Barry Kogut, and I'm an attorney with the law firm of Bond, Schoeneck King, participating in the firm's Environmental and Energy Practice Group. I will provide the legal perspective. My colleague, Ben Height, a professional geologist from GZA, will provide the environmental consultant perspective. Part 1 of this webinar series is to provide an overview of why one conducts all appropriate inquiries, or AAI, when buying and leasing real estate. Colleges and universities are often engaged in the buying and leasing of real estate and would also be confronted by AAI issues when in the position of selling real estate. In addition, performing AAI is also important for educational institutions when considering accepting title to real estate that is to be conveyed as a donation to the institution. Part 1 of the webinar will explain why one should perform all appropriate inquiries, and then we will walk through how to perform a Phase 1 environmental site assessment using the new ASTM method. Part 2 of the webinar will be held on Thursday, March 19th, and it will focus specifically on potholes that one can encounter in the Phase 1 ESA process. We welcome questions at both the webinar sessions, and we will leave time at the end of each webinar to answer questions. Questions can be raised via the chat or question box located in the GoToWebinar control panel on the right-hand side of your screen. If we do not get to your question today in this first 1-hour webinar, we will follow up by email. Let's begin with why conducting AAI is important. The discussion will focus on the 3 statutory programs listed on slide 3 that we will discuss in order. The first is a federal statute passed in the closing moments of the Jimmy Carter administration in December of 1980. This was the passage of what many still refer to as the Federal Superfund Law. However, its actual title is the Comprehensive Environmental Response, Compensation, and Liability Act, or CERCLA. CERCLA created liability for the response costs incurred to address releases of hazardous substances. Its passage changed the environmental liability landscape dramatically. New York State had already passed its own Superfund law the year before. That state Superfund law is known as the Inactive Hazardous Waste Disposal Site Law, and it is found in Article 27, Title 13 of the Environmental Conservation Law. And prior to that, in 1977, New York had passed Article 12 of the Navigation Law, which provided for a Superfund-like liability scheme for the cleanup of petroleum discharges. However, the focus in the early years was on CERCLA. Litigation resulted in case law pronouncements that CERCLA liability for response costs was strict, that is without fault, joint and several, meaning one responsible party can be responsible for the entire cleanup, and retroactive, meaning it covers disposal events that occurred prior to the effective date of the law. Liability for these costs can be to the feds, state, and private parties. CERCLA response costs include costs incurred to determine the nature and extent of contamination, an evaluation of possible remedial alternatives to address that contamination, and then the implementation of the selected remedy. The process is long, expensive, and usually unpredictable in terms of assessing how long or how expensive it will be. The most unsettling part of CERCLA liability is for an owner or operator of a site, because it doesn't matter if you did nothing wrong in terms of creating the environmental problem. Responsible parties under CERCLA are often referred to as PRPs, or potential responsible parties. This acronym was created to cover the laundry list of possible generators of hazardous substances that have been traced to a particular site. However, when it comes to a current owner-operator, you can remove the potentially unless you qualify for one of the CERCLA defenses. The CERCLA defenses are limited: act of God, act of war, or act of a third party who was not in a contractual relationship with a prior owner of the contaminated property. To claim that third-party defense and break the contractual relationship tie, one must establish that one did not know, nor had any reason to know, of the contamination. So is born the innocent landowner defense. And to assert it, one must conduct all appropriate inquiries. This will keep an owner from being subject to CERCLA liability. That photo on the slide is of my flatcoat retriever Bella, who loves the snow and is not always so innocent. Conducting AAI also has a role in limiting CERCLA liability in two other scenarios. First, beginning in January 2002, one could find contamination in the course of Phase 1 ESA and purchase a site with limited CERCLA responsibility. Such a party is known as a bona fide prospective purchaser, or BFPP. A BFPP still has certain obligations as an owner of the impacted property. They include taking reasonable steps to stop any continuing release, cooperating with those authorized to take response actions, complying with any use restrictions, complying with any requests for information, and providing all required notices. Second, the AAI inquiry is also required to keep one out of the CERCLA responsible party status if you want to purchase a contaminated site that is contiguous to the site that is the source of the contamination. The obligations assumed by the contiguous property owner are similar to those of the BFPP. So, the real estate industry is now very well aware of the need to perform at least the Phase 1 environmental site assessment, which means using the ASTM standard to satisfy all appropriate inquiries. The end game is to determine if there are recognized environmental conditions, or RECs, and the Phase 1 review is a non-invasive evaluation. If there are RECs, the next step is to conduct a Phase 2 environmental site assessment. Slide 11 provides the updated definition of what are recognized environmental conditions, and I will leave to Ben in his remarks to explore the details of that definition. However, it's important to step back and recognize that conducting a Phase 1 environmental site assessment is not a comprehensive assessment of potential environmental liabilities associated with the purchase or lease of a property. The categories of other sources of environmental liabilities are set forth on slide 12, and the last category, regulatory liability, can be the most significant. In sum, conducting AAI will address remediation liability or the cost of cleanup associated with problematic environmental conditions. However, there may be potential violations of an environmental regulatory program that could give rise to penalties and indefinite costs to address a non-compliant operation. For example, there may be an unpermitted discharge of wastewater that needs to be addressed. There could also be operational items such as an unregistered petroleum or chemical bulk storage tank. And there can be costs to be incurred to upgrade a PBS or CBS tank to meet the requirements of the applicable regulatory program. The regulatory, as opposed to remediation liability, represents a whole other scope of potential environmental liability that needs to be assessed in the buying of leasing of real property. The Phase 1 ESA professional can help with this, but it will be outside the scope of the ASTM Phase 1 ESA standard practice method, as Ben will later explain. But now, let's focus on what EPA considers to be an appropriate method for conducting a Phase 1 environmental site assessment. We start with EPA's approval of the use of the ASTM International Standard E152705 method in November 2006 to satisfy AAI. One of the advantages with the use of this method is that it looks for impacts of petroleum as well as hazardous substances. In fact, when DEC updated its Part 375 State Superfund Program, it specified the use of the ASTM E152705 method for AAI. ASTM then updated its Phase 1 ESA practice method with ASTM E152713. And EPA approved the use of this updated method as an AAI alternative in the December 30, 2013 Federal Register announcement. However, there was a concern about having both the earlier ASTM method and the updated method in play. So in June 2014, EPA proposed to delete the option of using the earlier method. In October 2014, it made the deletion of this earlier ASTM method final. The due date for the exclusive use of ASTM E152713 for AAI compliance is October 6, 2015. This development was one of the drivers of this webinar. Note that this amendment will not affect the use of ASTM 152705 prior to the effective date of the new standard. Before Ben walks us through the implementation of the ASTM E152713 method, I want to provide background on the two New York State programs that come into play in the Phase 1 ESA. They have a liability scheme similar to CERCLA and also look at the current owner and operator front and center in terms of liability for the cleanup of contamination. The photo that you see on the slide is one of my favorite places in New York State, Sackett's Harbor. We turn first to what is referred to as the New York State Superfund Program. In the event environmental contamination is detected in the course of the Phase 1 or Phase 2 investigation, the New York State Department of Environmental Conservation, rather than the EPA, is the more likely regulatory authority to be involved. The threshold for liability under the State Superfund Program is a finding of the presence of a significant threat to the environment, and then the remedial process followed is similar to that conducted under CERCLA. Of note is that the law itself identifies the owner as a responsible party, and the Part 375 implementing regulations define a responsible party to include, quote, any person who currently owns or operates a site or any portion, close quotes. DEC maintains an environmental remediation database in which indicates by county sites that have or are being addressed under the State Superfund Program. The DEC database also includes sites being addressed under the state's Brownfield Cleanup Program, or BCP, and the earlier Voluntary Cleanup Program, which was established by administrative rather than statutory action. The advantage here is that if the site is found on the database, there will be available information in the DEC's files of interest in the Phase 1 ESA. As you can see on the slide, the DEC also maintains other databases that are of interest in the Phase 1 Environmental Site Assessment Review. The spill database is of particular interest as it includes records on petroleum spills and whether the DEC has concluded its oversight of a spill. An innocent landowner defense was added to the State Superfund Program in connection with the passage of the State Brownfield Cleanup Program. That legislation refers to the 1997 ASTM Phase 1 standard. The DEC later updated the ASTM method to the 2005 standard in its regulations. However, as we noted, that standard is being phased out by EPA in favor of the 2013 standard. The state does not provide for all appropriate inquiries to serve as a defense against liability of a site owner or operator by qualifying for what EPA refers to as a bona fide prospective purchaser. That is, one who finds problematic environmental contamination, but still wishes to go forward under certain conditions, including access to allow remediation to be conducted. The theory at the time was that an entity finding contamination in New York should opt for the Brownfield Cleanup Program. However, practice has shown that it's not always easy to qualify for the BCP. Furthermore, now the legislature in New York must wrestle with the fact that the availability of tax credits for entry into the VCP are to sunset at the end of 2015 unless action is taken. Under its state Superfund authority, the state usually seeks to have what it considers to be the responsible party or parties enter into an administrative order and consent to implement the required remedial program. Although the state has authority under its Superfund program to require a cleanup, if it cannot convince a responsible party to step up and do the work, it can opt to conduct the required cleanup using state funds. DEC would then refer the matter over to the New York State Attorney General's office for cost recovery of the response costs incurred. The Attorney General's theory of recovery is CERCLA, and one will need to defend using defenses available under CERCLA. This underscores the need to use the updated ASTM method for a Phase 1 environmental site assessment. Finally, we look at what is missing under both the federal and state Superfund programs. It is remediation of petroleum impacted sites, as petroleum is not considered to be a hazardous substance. Petroleum is also not covered on the state Superfund program, but the definition of petroleum on the navigation law is very broad, as you can see by the definition on the slide. Similar to the federal and state Superfund programs, the scope of liability is strict liability. The scope of available damages is very broad and retroactive, and there is a private right of action, including a right of contribution. Of greatest concern is the potential reach of liability to the fee owner of the petroleum contaminated property. Under Section 181 of the navigation law, it is the person who has discharged petroleum that has a liability for all cleanup and removal costs associated with that petroleum discharge. So, is a fee owner a discharger under the navigation law? The fee owner would clearly be a responsible party if it not only owned the real property, but also the tank system under the ground, even if it did not know that a tank system was there and it was leaking and it did nothing to cause the discharge of petroleum. The more difficult question is, what if the tank system has been removed prior to the fee owner taking title, and all that remains is a petroleum-contaminated piece of property? Possible answer to that question starts with the New York Court of Appeals decision in New York versus Green. That case dealt with an attempt to impose liability on the fee owner of a mobile home park where one of its tenants had spilled kerosene from the tank that the tenant owned and maintained. The court was not willing to impose navigational liability based solely on ownership of the contaminated land. However, it held the fee owner liable in this case for the cleanup on the theory that it could control activities occurring on its property and had reason to believe that petroleum products would be stored there. From there, we go to the Court of Appeals case in State of New York versus Beyond Fuel, where the fee owner is found to be a responsible party for a petroleum cleanup because it had knowledge of the petroleum contamination at the time of its purchase and had the ability to remediate once it took ownership. In its decision, the court cited its prior decision in Green as authority. However, in so doing, the court conveniently overlooked the fact that the current owner could not have controlled the source of the petroleum because it did not control the premises until nearly 2 months after the defective tanks were removed. So, in sum, is Beyond Fuel a unique case? Perhaps. But the better caution is to be aware of the possibility of purchasing property that may have had petroleum storage tanks or to be contaminated by petroleum. This now leads us to performing the Phase 1 environmental site assessment, and I'm turning over the program to my colleague, Ben Height, who will discuss working with ASTM E152713.
Thank you, Barry. Why do I need a Phase 1? After all, it adds costs and can add time to the closing of a sale agreement. The answer is quite simply, it's better to know what you're getting into up front rather than discovering a more expensive problem after closing and the seller is long gone. Understanding the importance of this due diligence process and the protections it provides, it is essential to factor in the time needed to complete it into the closing schedule. Primarily, a Phase 1 allows for a broad assessment of potential environmental issues associated with the property. It establishes liability defenses under CERCLA and is nearly always required by banks and financiers when securing a loan to purchase a commercial or industrial property. Secondary benefits come when negotiating the final sale price. Environmental problems will reduce the value of a property and can be used as a bargaining chip to get the best price possible. The estimated costs to remediate the environmental problems are frequently factored into final purchase price. Not just anyone can conduct an ASTM Phase 1. The standard requires the use of an environmental professional, as defined here. Typically, the environmental professional will have a combination of experience, education, and licensure commensurate with one of these 4 definitions. Hold a professional license, such as a registered professional geologist or engineer in the property state, and have 3 years of relevant experience. Be licensed by the federal government, a tribe, or U.S. territory to conduct such work and have 3 years experience. Hold a baccalaureate degree in engineering or science and have 5 years of relevant experience, or simply have 10 years of relevant experience. An ASTM Phase 1 is not designed to uncover all of a property's dirty little secrets. While AAI does address petroleum and chemical contamination, hazardous building materials and naturally occurring hazards are not included. Items not covered by the standard include asbestos-containing materials, such as pipe insulation, roofing material, floor tiles, and drywall, lead-based paint, mold, PCBs and building materials such as caulk and floor expansion joints, radon gas, wetland delineation. A property condition assessment, wherein the physical integrity of the property's facilities is evaluated, is also not covered under the standard. This falls under ASTM Standard E 2018-01. Finally, ecological and historical resources, such as endangered species, and many regulatory compliance issues that Barry hinted on earlier, are not covered. These items can pose a significant financial risk to the purchaser above and beyond any environmental problems identified in a Phase 1. Many are covered under separate ASTM standards or regulatory guidance and programs. As Barry discussed earlier, ASTM issued a new Phase 1 AAI guidance in 2013. What are the major differences between 1527.05 and 13? Let's focus on new and refined definitions. The addition of historical recognized environmental conditions and controlled recognized environmental conditions, also known as HRECs and CRECs. Definition of migrate was refined to include vapor in the subsurface. We'll discuss this in a bit. Indoor air quality, except where impacted by petroleum or hazardous substances, now is beyond the scope of the standard. And agency file reviews are now to cover adjacent properties. Historical recognized environmental conditions, HRECs, include conditions that in the past may have been considered recognized environmental conditions, but have since been sufficiently investigated, remediated, and closed out with state regulators to residential or unrestricted standards. This can include items such as a once leaking petroleum storage tank that had been reported to the state, assigned a spill number, and cleaned up under a regulatory program such that the spill number was closed to unrestricted standards. Controlled recognized environmental conditions, CRECs, are similar in that they do not at the present pose risks that would be associated with a REC. A CREC is a spill that has been closed out by the regulators with a risk-based approach, whereby the hazardous substance or petroleum remains in place, but analysis has determined that it poses no continuing threat to human health or the environment. This is often achieved by engineering controls such as placement of an impermeable cap over the contamination or the installation of sub-slab vapor mitigation systems in on-site buildings. CRECs are important to identify because they can impact future development of the property. For example, a deed restriction might require a non-permeable surface to be maintained over the source area, such as a parking lot or concrete cap, limiting development opportunities. AAI is not intended to get nitpicky and identify every drop of petroleum or hazardous substance on a property. De minimis conditions, such as minor oil staining on an intact concrete pad, are not identified as recognized environmental conditions if they do not pose a threat to human health or the environment and would not result in regulatory action against the responsible party. Here's where a big change in the standard pops up: vapor migration. Vapor intrusion into habitable structures has recently come to the forefront of environmental investigation and remediation, and ASTM 152713 addresses the potential for indoor air quality impacts from subsurface petroleum or hazardous substances. Are vapors likely to migrate onto or within the property? For example, are vapors emanating from a contaminated groundwater plume on an adjacent parcel likely to migrate and impact the air quality of the subject property? Further screening and quantification of potential indoor air quality impacts is outlined in ASTM Standard E2600-10. Additional guidance in New York State is provided by the Department of Health in a 2006 guidance and supplemental tetrachloroethylene 2013 guidance. I'll now walk you through a Phase 1 environmental site assessment. It is important to gather as much information up front about the property as possible. This allows for more efficient investigation. A user questionnaire is provided to the user of the Phase 1. Typically, this will be the purchaser, not the seller of the property. The user will provide any information they know that may indicate the presence of a wreck, such as knowledge of past property uses, storage tanks, environmental proceedings, and any property documentation, such as surveys and as-built construction drawings. Federal, state, and local records are reviewed. As discussed earlier, this now includes the subject property and adjacent parcels. Historical information is researched. Data can include historic aerial photographs and topographic maps that can be used to determine past uses of the site. For example, where former buildings, rail lines, or storage tanks were located on the property. City directories are reviewed to determine what types of businesses previously occupied the property. This can identify long past uses, such as a dry cleaner, that could have a negative impact on property redevelopment. Geologic and hydrogeologic data are reviewed to determine the likely flow of groundwater, which could determine the likely transport direction of off-site contamination. An agency file review is one of the most important steps in the AAI process. Through Freedom of Information law requests, environmental records from state and local agencies that are publicly available, practically reviewable, and reasonably ascertainable can provide a comprehensive environmental history of the property. While this review is ideally completed prior to a site visit, they do take time, typically 10 to 20 days for a response. Complex environmental sites can add additional review time. Ideally, all the previously mentioned background data collection has been completed, so now it is time to visit the property. During site reconnaissance, we are primarily looking for visual evidence or the potential for wrecks or conditions that suggest HRECs or CRECs. We look for evidence of releases, such as petroleum staining or sheens. Such staining is typical of auto repair shops, retail gas stations, and maintenance yards. Chemical and bulk petroleum storage, including above ground and below ground storage tanks. The condition of these tanks is noted. A corroded tank poses a much greater threat than a new one. However, it is important to note if the tank simply has a fresh coat of paint designed to hide defects. Hazardous and non-hazardous waste storage and management areas and practices are observed. Are waste streams kept separate? How is waste oil handled, stored, and disposed of? The potential for pollution migration, such as floor drains and oil water separators, is noted. Often, floor drains will lead to an oil water separator, which, if it isn't operating properly, can cause the release of oil or other substances to the environment. Utilities are identified. Is the property heated with municipal natural gas or on-site fuel oil? Does the property use a private septic tank into which contaminants from drains could be accumulating? Is there a private well that could be drawing in adjacent contamination? Evidence of past contamination can be used to identify RECs, HRECs, or CRECs. Such evidence can include groundwater monitoring wells, stockpiled soil, or waste drums. It is important to compare these items with records obtained from the agency file review to determine if regulatory action has been taken on the property. Transformers and electrical equipment can suggest the presence of polychlorinated biphenyls, PCBs. PCBs are a main and expensive chemical concern for many high-profile environmental remediation projects in New York. Ponds, lagoons, and impoundments are important to note, as they can provide a contaminant pathway to soil and groundwater. Do they contain fresh water or a waste product from an industrial process? Likewise, dry wells and sumps can provide a direct contaminant pathway to soil and groundwater. Stressed vegetation can be indicative of a petroleum or hazardous substance release. And finally, burn pits and waste piles can likewise be sources of contamination, particularly solvents and heavy metals. Interviews provide valuable information. Current owners and occupants can explain the uses of the property and any processes that may pose a threat to the environment, as can previous owners and occupants. However, it of course depends on how forthcoming they are. We'll talk about that in a minute. Local government officials should be interviewed to see if they are aware of any such threats, such as past fires, illegal activities, or dumping. Data review and site reconnaissance observations and interviews are evaluated and compiled into a report for the user. This report includes a discussion of data gaps. These are areas where an environmental professional was not able to obtain adequate information to evaluate the possibility of wrecks. Identified wrecks are called out and discussed. A vapor intrusion evaluation is included, whereby the likelihood of vapor migration is reviewed. A section of the report will include limitations and reliance information, where the environmental professional has explicitly written out limitations to the report and who may rely on it. Limitations should first be presented to the user in the environmental professional's proposal prior to engaging the work. Data gaps occur when the ability to obtain required information, despite good faith efforts, is hindered. These can occur from the lack of access to the property or parts of it, the lack of historical records, key personnel are unavailable for or unwilling to provide interviews, or the current owner and occupant are uncooperative. When deciding to complete a Phase 1 environmental site investigation, it is important to keep in mind these considerations. It is a first-order, non-intrusive investigation. It is not intended to identify what contaminants are in the ground, just the potential or likelihood that they might be there. It is site-specific and requires site access. File reviews are important, but can take longer than might be provided for in the transaction schedule. Closing dates rarely take into account these extended time requirements. Cooperation between the purchaser and seller is key. The more information provided up front, the easier and faster the process will go. The Phase 1 must satisfy lender requirements. Lenders may have requirements that go above and beyond ASTM standards. They may require the use of pre-approved environmental professionals. The Phase 1 is valid for 180 days. If your closing date is 181 days from the Phase 1, you have to do it again. Reliance is limited. Typically, only the purchaser, their attorney, and the bank can rely on the accuracy of the Phase 1. I have two case studies for you. One where an inadequate Phase 1 resulted in an unexpected environmental remediation costs, and one where Phase 1 was used to evaluate required remediation of a property for successful redevelopment. A missed recognized environmental condition resulted in unexpected environmental costs to the property owner and, in this case, the user of the Phase 1. The Phase 1 did not identify the presence of an underground storage tank. However, other wrecks were identified, and an intrusive investigation of Phase 2 was conducted to characterize the nature of, if any, contamination in the soil and groundwater. During the intrusive investigation, the integrity of the storage tank was compromised. This and subsequent activities resulted in the release of petroleum to the subsurface and ground surface. This resulted in additional subsurface soil and groundwater sampling and a subslab vapor migration investigation of the immediately adjacent building. Multiple state and local agencies became involved, including the New York State DEC and DOH, complicating the timeline for site redevelopment. The proximity of the incident to the property building resulted in negative impacts to daily operations and required consideration of the building's foundation integrity during impacted soil excavation. Ultimately, this cost in excess of $150,000 just for the environmental investigation and remediation. Additional attorney fees and loss of business income added to the financial impact. Here we can see the close proximity of the incident to the building impacted daily operations. Soil excavation this close to the building footers required careful and deliberate work and consideration of the foundation integrity. The second case I have for you is much more uplifting. A proper Phase 1 ESA was completed and assisted in determining environmental remediation costs. These costs were factored into the purchase price of the property. Upon successful remediation, a blighted vacant property was redeveloped into a successful commercial business. The property consisted of two separate parcels, both former gas stations and auto repair shops. The Phase 1 determined the likely presence of petroleum and underground storage tanks, both wrecks. The buyer was motivated to close, but needed a clean bill of health from the seller. Subsequent Phase 2 subsurface investigations confirmed the presence of petroleum contamination. An estimate of $400,000 was developed for remediation, including regulatory closure of underground storage tanks, and factored into the sale. A risk-based approach was developed to determine allowable site-specific concentrations of petroleum constituents for the protection of public health, essentially creating a controlled, recognized environmental condition. The site was successfully remediated with cooperation from DEC and DOH and granted regulatory closure within the developer's time frame and on budget. Here we see one of the underground storage tanks being removed during remediation. And upon completion of remediation, the building went up and development continued as normal. The presence of wrecks may result in performance of a Phase 2 subsurface investigation. This investigation aims to quantify what contamination, if any, was contributed by the wreck to the surface and subsurface. It typically entails soil, groundwater, and surface sampling and can fill in data gaps identified in the Phase 1. It is important to note that if contamination is confirmed, a spill may need to be reported to the state regulatory authority. The onus to investigate and remediate this spill, along with the associated costs, then falls on the property owner, not necessarily the user of the Phase 2.
And that takes us to the end of the implementation of the Phase 1 ESA using the updated method. I think now we want to move back a little bit through Ben's presentation and just ask a couple of questions here in terms of some of the details that he provided us. The first one, Ben, that I'll go back to is really goes back to slide 26, where we're talking about the need for an environmental professional to conduct AAI. And as you laid out there, one of the folks who in fact can do that is one who's been out there for 10 years and has relevant experience. And maybe you can tell us what is relevant experience.
Sure. Relevant experience would entail or would come from assisting with this sort of investigation in the past. Maybe not necessarily being the environmental professional, but assisting the environmental professional. It includes other environmental work such as site investigation, remediation, participation in regulatory guided projects for investigations and remediations.
Okay. Can someone who does not qualify, can they still be on the team?
Yes, as long as they are working under the environmental professional.
Going down to the next slide there, non-scope Phase 1 ASTM, you referenced another ASTM method, I think in the category of the property condition assessment,
yes.
ASTM method. You can maybe just mention that, what that is, because maybe it's with vapor migration or are other methods that may in fact be implemented here.
There are. And I'm not familiar with the property condition assessment. That's usually handled by an engineer or so forth. But there are ASTM standards for most of these, including the PCBs, the asbestos, and mold.
Okay. Moving on to recognized environmental conditions, and now we have this new category of historic recognized environmental condition. One of the things that comes up frequently is looking at the DEC spill database, which is referenced earlier on as part of the available information that the DEC provides. If you go on one of those spill files, they'll just indicate that, for instance, the spill file is closed. So how do you know whether or not it qualifies as a historical recognized environmental condition? Because as we know, the DEC, even though they close a file, they reserve the right to reopen.
Right, and even if it's closed to unrestricted or residential standards, that same caveat applies. We would need to see the site file from the DEC, which would come from the file review at the DEC offices. And then we would review that closure report, review the analytical data to see if, in fact, it does live up to the historic recognized environmental condition.
What are the standards that you use for purposes of determining whether or not it's no longer a wreck, if you will, but just historical?
If it is closed out to, the state of New York has 4 or 5 categories of soil guidance criteria. The most stringent are called residential or unrestricted use. That means you can develop the property as you see fit. There shouldn't be any resulting problems from the former spill. That's the only instance where I would call it a historic recognized environmental condition. If it is closed out to industrial or commercial soil standards, it would not fall into the HREC.
Okay. Who looks at the spill database? Is it the environmental professional, or oftentimes I've seen the environmental professional relies on a third-party vendor?
Yes, often we do use we routinely use a third-party vendor to reach out and collect data from a multitude of different databases, including state, federal records, tribal records, waste manifest records. Those all come in and are part of this report. However, the environmental professional is responsible for verifying those and checking independently to see if anything is missing from that third-party report, which it quite frequently can.
Look in the vapor migration there, slide number 31. How does that review appear in the report? I mean, do you set forth what the standards are, or what are the criteria that one should look at when they get that report from the environmental professional?
I haven't had this is a relatively new standard, and I haven't had any of my phase 1s come back where we determined there was a vapor migration problem. So in that instance, we simply put in the report that there is no, we do not consider vapor migration to be a recognized environmental condition at this property.
Are there EPA criteria in play as well? You referenced here just the DEC.
EPA has been working on guidance documents citing RCRA and CERCLA and a few other regulations for the better part of well over 10 years now, I believe. They are still in draft form. They reissued drafts in 2011 and I believe 2012 for public comment, and they are in the process of finalizing those.
I mentioned DEC. DEC actually relies on DOH guidance
yes.
as for purposes when they do their remediation. They refer back to that agency. Going on to the next slide, there is slide number 32, talking about the user questionnaire. What are you looking for in the user questionnaire? Is there a standard form questionnaire that one should expect to receive from the environmental professional?
The standard has a list of what should be asked for in that questionnaire. It includes knowledge of environmental liens, knowledge of any chemical or petroleum bulk storage, essentially a list of anything that could be considered a wreck. And then typically each environmental professional or consultant will take those questions out of the standard and put them in their own form that will be issued with the proposal to do the phase one work.
Looking down on that list, records review. Any insights in terms of what agencies, at least here in New York, are most problematic in terms of either timing, completeness?
Typically, the state is good. I haven't had many problems. They can ask for an extension, so they're supposed to get back to you within 20 days. They can send a letter saying it is taking longer, and then that'll have to push your time frame back. The local agencies are typically where I have more problems, especially in smaller municipalities where it's not clear which department has the records I want to look at. They may not know where they are. They may not have them adequately organized. So that can, the local government is usually where that problem comes up.
As you mentioned, we have a right to those records under the New York Freedom of Information law with respect to local or state records. The federal agencies can be accessed by using the federal analog. They're the Freedom of Information Act. Do you make requests of EPA or other agencies as a typical agency review?
Typically the EPA and federal databases come back with that third-party report that we talked about earlier. Unless the site is under an EPA program, either permitting or Superfund, or unless it's under one of those regulatory regimes, we typically don't do independent FOIL requests to the EPA.
Okay. We're talking about these two different methods, going from 05 now to 13. Any guidance in terms of costs and time? I mean, obviously, the 13 is a more comprehensive way of looking at some of these issues.
Yep. And
is it possible to sort of give sort of a rule of thumb in terms of what we're talking about in terms of increase in time and cost?
I can't quantify it, but it doesn't add a lot to the time, and with any project, we'll evaluate it individually for the cost. I don't think there's a significant increase in cost between the two standards.
Okay. I want to just now look back at our slides. The last slide there, 50, is a list of those topics that we'll be covering on our next webinar here, part 2, in which we'll get into some details with respect to practice pointers, going through and hiring the environmental professional, what the contract should say, what some of the issues are. As Ben alluded to here, we have some questions relative to scope of required notification in terms of what one sees when one is on site and looking for these environmental conditions. Confidentiality, oftentimes that's a concern clearly of the seller and oftentimes is the buyer of well. Use of prior phase 1 environmental site assessments. It's been noted after 180 days they've lost their shelf life, but there still could be information there that's very helpful in terms of doing a more recent phase 1. Third-party reliance. We have seen recently requests for user reliance letters that come afterwards, and how one should deal with that when that third party has not been the party that has retained the environmental professional. User obligations, what that entails. Environmental liens. There are federal liens that come up under the CERCLA statute. There are liens under the petroleum law, the navigation law. We can walk through what they mean and how they are in fact impacting the property. And then agency file reviews. One of the things that has come up recently, really in the context of our firm's e-discovery and information management team, the new email retention policy for New York State. The full article can be found by going to our website at www.bsk.com. But just to read the first paragraph of the information memo. It says, according to recent media reports, New York State has now implemented the 90-day email retention policy that was previously announced by the Cuomo administration in June 2013. The reports indicate that various state agencies' disparate email systems have been consolidated on a single cloud-based platform, which will automatically delete emails 90 days after being sent or received, unless specifically retained by the employee in the special file folder. With the implementation of the new retention policy on February 23, 2015, the mass deletion of state emails currently older than 90 days is apparently underway. Again, I have seen that when one looks for information about a particular site, its environmental condition, you oftentimes come across old emails that are in the file in which there is information which is very helpful. And so I'm not quite sure what impact this is going to have. We're hopeful, obviously, that the environmental professionals, if you will, that work for the state recognize the importance of maintaining this kind of information, even looking far back in the past. But this was something that has come up, and I think we should, in fact, be aware of. Then we talk about non-scope items. There's a list of those that are in the earlier slides, and we'll talk about some of those items in terms of things to take a look at by way of assessing the environmental condition of the property, things like the presence of asbestos, the presence of PCBs and building materials, mold questions, things that in fact can impact you if you purchase that property and now want to develop it. Again, not something that falls within the category of a recognized environmental condition, indicative of a release that requires a remedial response, but something that still can impact the bottom line in terms of that development of the property and impact perhaps the thought in terms of the future use. And then finally, we'll hit upon one of the other Phase 1 ESA tools, which is used for forest land or real property. And again, as been alluded to, there are a number of ASTM standards in play which are to help guide one in evaluating some of these issues and providing for a more comprehensive evaluation of the environmental condition of the property. So we ask that if you would like to join us for that, and we certainly urge that you do so, that will be on Thursday, March 19th, and it will be necessary to once again register for that program, and we will send that information out via Evite, and a similar procedure will follow in order for you to, in fact, gain the PowerPoint presentation and to be able to hook up to this program. And that concludes my comments. I don't know, Ben, if you have anything further to add to the evaluation of this particular part of the webinar.
I think when we discussed that second Phase 1 standard in the next in 2 weeks, the 2247, I think that would be of particular interest for our audience, given the rural, very rural nature of upstate New York and institutions' ownership of that land.
Okay. Well, thank you, Ben.
Thank you, Barry.
And thank you, those who have registered and have been in attendance. Thank you for attending today, and have a good afternoon.